Leather boots on courtroom floors, 26 years behind closed doors. Files marked confidential, truth suppressed, but I write in with justice on my chest. From crime scene to courtroom, I've seen it all. I see my priest and wait for the judge's gavel to fall. Every child matters, no case too small. I feel their pain and hear their frightened call. A voice for the voiceless, I won't let go. I speak the truth they need to know. This is crime, courtroom confidential. Silence breaks and hearts are hurt. We fight for the ones the system never saw. Every story, every word, no secrets buried, no pain ignored. Justice rides in bold and raw. This is truth, unfiltered, and I'm not backing off. My hair prayer hums beneath the sky. Courtroom robe and a watchful eye. Tattoos tell stories, scars that stay. I've lived alone in every way. From crime scene to courtroom, I've seen it all. I say my piece and wait for the judge's gavel to fall. Every child matters, no case too small. I feel their pain and their frightened call. A voice for the voiceless, I won't let go. I speak the truth they need to know. This is crime, courtroom confidential, where silence breaks and hearts are hurt. We fight for the ones the system never saw. Every story, every word, no secrets buried, no pain ignored. Justice rides in bold and raw. This is truth, unfiltered, and I'm not backing.
Hi everyone. Okay, so today I want to have more of a conversation about Jack and Lilly Sullivan. So, very brief go back over it. Jack and Lilly are, Jack is 4, Lilly is 6. They went missing from Nova Scotia, Lansdowne Station. On the 2nd of May, they were reported missing at 10:01 by their mother, Malehya Brooks-Murray. They lived on the property at Gairloch Road in Lansdowne Station with their mother, her boyfriend, Daniel Martel, their half-sibling, Meadow, and on a in a camper on the same site lived Janie Mackenzie, who is Daniel Martel's mother. There have been some content creators who have looked at either the articles that came out following disclosure of some court documents or the actual court documents themselves, because people have obtained them from different sources, who have made some interesting determinations from that. One of them is the parents have been cleared, or Malehya and Daniel have been cleared. Nowhere in those papers, and I've got the actual papers, does it say Daniel Martel and Malehya Brooks-Murray have been cleared. It does say that they passed or demonstrated truthfulness in relation to 4 questions they were asked in a polygraph exam. But we only know what 2 of those questions are from Daniel. They weren't very good questions. They would be very easy to answer technically truthfully whilst still having done something nefarious. in all the circumstances of this case. And there were a few different things that different people have said that concern me a little bit. And the reason is this. I'm a lawyer, as you all know. I specialise in criminal law and child protection law. And I've been doing this for 26 years. I know a little thing or two about the law. I also know that when I'm looking at a case, whether for work or for YouTube, before I say anything, I like to research it. Sometimes you get caught off guard, you get asked a question, you say something based on your own knowledge and it's incorrect. And if that happens, I will always correct it at a later date. But I like to try and do my research. Why I haven't come on and spoken about the documents themselves yet. So I did a breakdown of what I found within the articles. I now have the full set of documents, but I'm not going to speak about them until I've read them. When I say read them, I mean it can take me hours to go through 100 pages. There's 527 pages. And the reason that it takes so long is because I'm going backwards and forwards to double check things against each other. So I will do a breakdown of what I find in those documents, and I'll take you to a few of them, but not yet, because I've nowhere near finished it. I apologise for yesterday not doing this live because my father-in-law had a really nasty fall. He's in his 70s. We had to take him to hospital. Well, we got an ambulance to take him to hospital, but we had to go with him. He's okay. They've let him come home today. He blacked out. They don't know why. In any event, he is okay-ish. But the first thing I always like to research before I come to any conclusions about the information that I have at hand is what the law says about it. And so that's what I want to focus on today. I want to focus on some areas where the law has been significantly misrepresented or something has been said without knowledge of the law. Now, I'm a UK lawyer, so I don't have the kind of in-depth knowledge 26 years of practicing in it gives you in relation to Canadian law. But I do have a pair of eyes, a legal brain, and a bit of an analytical brain. So I've had a look at some of the areas and I want to talk about them. Redactions in the documents. So in the court documents that have been released, there is a lot of redactions. You'll notice if you've seen any of the documents that it shows where it's redacted, on top of it, it shows in a different colour the reason that they are relying upon. And you'll understand why that's important when we start to go through the reasons why one might redact. It's important that if you choose to redact something, you explain why, what the basis for that decision was. Where it's personal information, that can be any information that can identify a person. And then where they talk about delayed disclosure, that fits into one of the categories. So we'll have a look at what those are. Now, while I'm looking at this case, I'm keeping an open mind. I'm looking at all the avenues. how likely or unlikely each of the potential theories are, or the bits of information that we hear about. I try and follow the evidence, understand what the court documents are actually showing, and it isn't always as simple as A, B, C. Sometimes it's that they're showing that they've done X in their investigation, and so you can be content that they have followed a particular lead, for example. I look at consistency and inconsistency in the key elements of the timeline. I look at it overall because, as far as I'm concerned, if you demonstrate dishonesty, it makes it very hard to believe anything else you say. And that isn't just me saying it as a person. That is the way that we treat people in a courtroom. If you're on the stand and you are demonstrated as having been dishonest, my next point to you will be, what makes you think that I should ask this jury to believe a word out of your mouth? So, I like to understand the value of different types of information, depending on their reliability. So we have some information that the RCMP has verified by third parties or by CCTV or by certain records. And then we've got things that people have said. Some of that will come from very reliable sources, officers, teachers, people with absolutely no skin in the game. And then other things are stated by people who are closely involved with the circumstances. That makes it slightly less reliable. And if they're inconsistent, that makes it significantly more unreliable. We know that the key period that we need to understand what happened is between the 1st of May at 2:25 p.m. when the children were seen on CCTV footage walking around the Dollarama store. And I can now confirm, having read the documents, or some of them, that they were seen on the CCTV actually walking around. Okay. And 2nd of May at 10:27 a.m, which is when the RCMP arrived on scene after Malehya's call at 10:01. I look at statistical analysis and the likelihood of each possible outcome. I look at geographical information, victimology, so what about the victims do we know? And a really good example of that would be Sebastian Rogers. We heard very early on that he doesn't like to go outside without his shoes on because he once, as a young child, stepped in a pile of fire ants. Ever since then, he's been terrified of going outside without his shoes on. And yet we're asked to believe by his mother that he independently of his own volition walked out of the house in the middle of the night with no shoes on. So that's looking at victimology. Okay. It might be that a victim is autistic. So then we need to look at, are they verbal or are they non-verbal? Do they have particular issues with going outside alone? Do they have particular issues interacting with people they don't know? Do they have particular environmental issues that, so say for example, you don't like the feeling of grass on your feet, or you don't like feeling of leaves brushing past you, because a lot about autism is around sensory impact. We also look at suspectology. What information about the wider life and circumstances of not only the victim, but the family members and potential persons of interest do we know? Are there any former issues? Are there any risk factors? What's the makeup of the family home in terms of the people that live there? I try and understand one very key law enforcement and legal concept that we use, which is that the best predictor of future behaviour is past behaviour. So where you have a person who is known to be physically abusive, or is known to be controlling and coercive, or is known to always stay up all night, what we know is that people, because they are human, they get stuck in patterns. And also we know that personality traits don't generally change dramatically. I take into account information from people who train law enforcement officials, who train the FBI and the NCA how to interrogate people, how to read people, how to identify deception. I also take into account the views of people who are really well trained and experienced in statement analysis or behavioural science, or who are highly experienced and have lots of expertise in homicide investigations. So there's one particular person that I absolutely really kind of, 100% value the opinion of, who's got over 300 homicide convictions. His success rate is over 90%. They've got many, many years of experience in that field. And even though they've retired, they remain actively involved in investigations because they are part of a cold case foundation. There are other people who are experienced trial lawyers who I take the opinion of very seriously. But I am always very careful about taking account of people's opinion if they describe themselves as former law enforcement lawyer, statement analyst, whatever it might be. They don't tell you what their experience is. And the reason for that is this. You've got the experience that makes you an expert in an area, and you'll say so. Haven't got the experience, you'll be really vague about it. A little bit like suspects or people in the family. If they know that they are innocent, they will give you a detailed timeline that makes complete sense. If they may have guilty knowledge of some kind, they'll either be very vague or very inconsistent, or both. So before you take the word of any YouTube creator, or anybody in your life for that matter, if they call themselves an expert, or they call themselves experienced in a certain area, ask them to verify what it is that that experience is. So let's have a look at the actual law. And that was a really long-winded introduction, and I really apologise for that. But so who have we got in the room? Kimmer, hi, lovely to see you. So let's have a quick look and see what we can understand about the law in the area where these children went missing. So first of all, redaction. It's very similar to the UK law, actually. So we have freedom of information requests. In Canada, they're called Access to Information Act requests. Okay. And there's similar basis to refuse to disclose particular information. And there's a few of them that are relevant here. So what I will say is, before I start getting into this, I've had to redact thousands and thousands of documents in one go on very many cases, or I've had to check when an assistant has done it, because you can't rely on the fact that they've definitely done what you've asked them to and they've caught everything. It is hard to go through document after document after document talking about the exact same thing and spot every single bit of personal information and every single bit of information that might harm a case. Okay, so people make errors. And the risks are immense. But how much time and effort you put into those redactions in many ways depends on the risk level in the case. So I've had significant cases where there's like political involvement, or the Prime Minister's involved, or there's organised crime gang involvement, or credible threats to life to the individuals in the case. Now, for those, you're going to check it, and check it again. Where there is a risk to the child's safety, if a parent finds out an address of where they're staying, you're going to check it repeatedly before you send the document out. The other thing I'll say is, usually in government departments, it's the lawyers of that government department who will deal with redactions. It's not the officers in the case in terms of police stuff. Okay. So what the Access to Information Act actually says is that the government will, not might, not can, will refuse to disclose all information relating to a live investigation. So I have to ask, why have the RCMP released the documents that they have? Seems to be contrary to the Act. I suspect that somewhere in the Act it gives them the option to, if they need to, okay? But it's why it is very unusual. There is also a section in there that says that if they do release information, it should be available to government officials and the public at the same time. So, what information would we generally redact? So let's look at that first. What information would we generally redact in or refuse to disclose in this type of case? Third-party identifying information. So that's your personal information. So it can be personal information that people don't need to know about in relation to the parents. But it should also be any information that can identify, whether by itself or as a jigsaw puzzle of the information available, any third party. And that includes witnesses. Now, there are a number of witnesses whose names are not redacted. It may be that the RCMP ask whether they require their information to be redacted in any documents. But I suspect it's more likely that it's an error. If it is a police officer, a health professional, or an education professional, you don't normally need to redact those. And that is because they expect their information to be in the public domain as a member of that profession, not the rest of the personal information. It includes protected characteristics, so race, ethnicity, religion, disability, all of those things. And a person is entitled to have their privacy maintained unless certain exceptions are met. So that can include health, safety, or environmental concerns that overrides the right to privacy. Safety of individuals requires information to be disclosed. The prevention or detection of crime, and the economic interests of the state. Information, so other things that we might redact, information that might harm the integrity and outcome of an investigation. That's directly from the Act. That's case-specific information. So details around, say, for example, a time frame that is in dispute between the different people involved. They may not want to put that into the public domain, what each of them are saying, because they want to be able to see if they maintain their inconsistency. But it can also include non-case specific information that relates to future conduct of lawful investigations. So investigative techniques, if it's going to make it easier for people to commit the crime or harder for them to detect the crimes, make people more forensically aware, that can mean that less people get caught. Okay, so that is why you will often hear officers who are on shows say, I'm not going to talk about the detail of how we do that. That's the reason why, because they don't want people to become too aware of the techniques that they use so that they can find ways to circumvent that. Legal professional privilege, that's another bit of information that would be redacted. So that could include correspondence between lawyer and client or advice provided by the lawyer to the client. And litigation privilege, which is slightly different, and that's any records that are created for ongoing or anticipated litigation. Okay? Any information that public safety requires its redaction. So an example of this might be information that might incite a riot or might allow people to identify a mark for criminal activity more easily. So an example of that would be where the police publish photographs of a child in a school uniform, but they blur out the uniform so you can't tell which school they go to. Or where the safety of individuals requires that it is redacted. So that could be witnesses who could be targeted by suspects or the general public, because we know there's quite a few crazy people out there, or suspects because they could be targeted by witnesses, victims, victims' families, or the general public. Okay. So what have the RCMP actually redacted? Now, I haven't looked at all of the documents yet, but they seem to fall into two categories: personal information and delayed disclosure. The personal information appears to be things like some addresses, the dates of birth of the children, and some witness names, telephone numbers, email addresses, and health information. And there's some other bits where I can't decipher what it might be. But they're the general categories of personal information. There are bits of personal information in there that should have been redacted. So there are third-party witnesses who are not members of the professions that are talked about, whose names should really have been redacted. And that includes the person who gave the tip about seeing two children on the morning of May the 2nd, walking down the road holding hands towards a gold or fancy sedan. Some of the family's acquaintances are also not redacted. So the fact that they've missed those bits of information is not surprising, because people make mistakes when they're doing redactions. It also may be that they've not given a good enough brief to the person who was carrying out the redactions, so they didn't realise that those ones needed to be redacted. Or they may have provided consent. But it does put those individuals at a certain level of risk. That's why the rule's there. And they're entitled to privacy. And then the stuff where it is delayed disclosure seems to be areas where there is conflicting accounts by people, or there are certain parts, for example, a mystery witness that was interviewed on the 9th of May, literally it's completely redacted. So that could be a really key piece of information they absolutely don't want the persons of interest to know that they've interviewed, because it'd give them some idea of what they know about what happened. But the bits around conflicting information would be, so the time frame that Lily popped her head into the bedroom, time frame that the children are believed to have left the house. There's a specific records access request as well on the 23rd of May that's completely redacted, and it is completely redacted, so I've got no idea what that records request is either. Now, this delayed disclosure is not because the police seem to have ruled it out. not because the police feel like redacting it just because, not because they're being difficult, not because it's unfounded. It's got to fit into one of the exceptions that we talked about. So the most likely exception is that it could harm the integrity or outcome of the investigation. And we know that those timeframes in particular are key to the investigation because they're key to the nexus of the disappearance. Who last saw or heard the children and at what time? What time did the children leave the house? So the last thing you want to do, and I think I've said this before about I don't want to delve really deeply whilst this investigation is ongoing into the specific inconsistencies that the different parties have made across their own accounts and across each other, across the different people, because you're arming them with knowledge that would hamper the RCMP's ability to investigate. And we talk about the odd one or two, but I think we have to be very careful. So that's redactions. The next area is seizures of evidence and searches of property and search requests for copies of records, okay? So there was a reference to the idea that Malehya took Daniel's tops at the RCMP's request, and this was on the Drunk Turkey show. And I've got no issues with Daniel from that show coming up with different theories and all of those things, but this concerned me greatly because the way that he described it was not that it was his theory. So he made it sound as though it was a fact that Malehya took Daniel's tops at the request of the RCMP and handed them over for analysis. Now, the idea that a former law enforcement person would suggest that this is a possibility blows my mind, because that would cause a major issue. It would cause a major issue because if they asked her to do that after Daniel and Malehya split up, which is when the tops went missing, they would be asking her to enter somebody else's property without permission, number one. Number two, it would impact on the forensic reliability of anything that was found on those tops, because Malehya has had them in her hands. It wasn't the police that seized them. They can't guarantee that that is what he was wearing at any given time, or what Malehya did with it in the interim. So it would be useless as a piece of evidence. So they absolutely wouldn't ask her to do it. That being said, and let me just give you a little bit more background on my experience. Not only am I a lawyer, and a very experienced one at that, I also spent years during my legal career as a kind of a side to it, because it helped with my prosecuting. I trained as a counter-fraud investigation manager. So I trained in investigative techniques, interrogation styles and tactics, covert surveillance tactics. And I've been able to put those bits of training to very good use throughout my legal career. So for me, there are three questions. Did Malehya actually take the tops? We've only got Daniel's say-so for that. If she did in fact take the tops, did she hand them over to RCMP? And did she do that off her own back? Now, I've not read all of the court documents, so I can't say whether it deals with that, because I haven't reached that point yet, if it does. But hopefully I'll have some more information about that when I finish reading them. There's another reason why it would be beyond unethical for a police officer or an RCMP officer to ask any person who is not an officer to go and seize, touch any evidence or conduct any kind of search. And that is because in Canada, you have the Canadian Bill of Rights. It contains no specific rights to privacy or to be secure against unreasonable search and seizure, but it does have Section 1A, which protects a limited right not to be deprived of the enjoyment of your property without due process. And you also have the Canadian Charter of Rights and Freedoms. Section 8 of that protects people against unjustified intrusions on their privacy interests. We have similar laws in the UK and rights. So if Malehya went into the property to search for particular items, he would be acting as an agent of the RCMP and thereby enabling the RCMP to breach Daniel's Charter Rights and Freedoms. Okay? And it would be a willful breach of those Section 8 rights. She also doesn't know how to protect and maintain the integrity of a piece of evidence if she were to attempt to seize the same. So when a police officer seizes a piece of evidence, they don't grab it with their bare hand, carry it, and drop it on the desk of a police officer or a different police officer. They very carefully photograph the items in situ. They put on gloves, they get an evidence packet. They use the gloves or pincers sometimes even for extra protection. Put the item in the packet. They seal it. They write on it what it is, their name, the date and time that they seized the item. Anytime anybody wants to look at that piece of evidence, they have to record on that evidence log their name, rank, reason that they opened it, date, time that they opened it, date and time that they resealed it. And when they finish, they've got to reseal it. And that's called a chain of evidence, and it happens all the way through, from right at the very beginning until the end of a judicial process. The other issue with it, of course, is that if they asked an ex-partner to go into their ex-partner's property after a separation, particularly one if they have made any reference whatsoever to the police, or there is any suspicion on the police's part that there is any level of DV, coercive control, or anything else, they're putting the individual at risk by asking them to go into the property. They're actually putting their physical safety at risk. So it would never, ever happen. Hi, Susanna. Hi, Paula. Yeah, there's a heck of a lot in the documents, Susanna. I've not read them all yet. Hi, Mike. Yeah, so any kind of, the RCMP would never ask another person to go and seize a piece of evidence, number one. And there are so many flaws with that concept that I can categorically say it did not happen that way. And if it did, RCMP will be in really serious trouble. So that's that piece of law. The final piece that I wanted to talk about in terms of legal bits is Missing Persons Act powers. So they provide, this is kind of the opposite of someone's protection against being searched or having things seized from them. This is what powers do the RCMP have to search and seize. And there's been lots made of the fact that it's remained a Missing Persons Act investigation in name, on paper. And I don't think that for 1 minute demonstrates that the police don't believe that something else might have happened. Police officers will have their theories, and they will sit and actually do huddles where they just throw out theories and then talk about what are the pros and cons of each of those potentially having happened and what evidence they can go and look for to prove or disprove that theory. But what they write in court documents is a very different thing, and they're only going to talk about what they actually know, okay? We also know that this police information is quite out of date at this point. We're a month on, things can have changed dramatically. However, what can they do under the Missing Persons Act, given that's what on paper in name they are calling this? So there are two pieces of legislation. One is the Missing Persons Act, SNS 2012 C47. And the other is the Missing Persons Regulations. Bear with me because I've forgotten what they're called, which is very foolish. Missing Persons Regulations, and then I think it says something like pursuant to the Missing Persons Act. So, under the Missing Persons Act, Section 5, it provides the RCMP with the power to apply for a search order. So, the court can, having heard information provided on oath by an RCMP officer, provide authorization for any law enforcement agency to enter by force, if necessary, the dwelling or other premises of a person in order to search for a missing person. Now, what basis do they need? So they need to demonstrate in their information provided under oath that there are reasonable grounds to believe that a missing person who is a minor or a vulnerable person may be in that dwelling or other premises. It's not quite as high a bar as probable cause that something did, an offence did get committed. And the reason that it's wider is if it's children and vulnerable people and they're missing, we need to be able to search as freely as possible whilst balancing the rights of the people. Hi, Angelina. Right, so then we've got a record access order, which can be requested under Section 6. And this can be for any records or copies of any records set out in the subsection 2 of that same section. So the list is this. Records containing contact or identification information, telephone or other electronic communication records, wireless device records, cell phone records, inbound and outbound text message records, internet browsing history, global positioning system tracking records, video records, including CCTV footage. So we see in the court documents that there are significant numbers of records requests that were made. And that's a good thing. However, they were made very late in the day. And that's a bad thing. I'm doing a breakdown of the actual investigation timeline. So not the timeline of the offence, the circumstances of the disappearance, but the actual investigation itself, because it reveals quite a lot about the RCMP focus and also the places where they dropped the ball. What I will say as well is that there were a variety of premises searches carried out. It still concerns me that they went into Janie's trailer 3 times. The first time was one of the ground search and rescue team, so it wasn't an RCMP officer, so they will not have been looking for evidence. It's literally a sweep to see, are the 2 children hiding in here? That's it. Then officers came back and searched, but that was after some time had passed. What I will also say is they did searches, but neither in Janie's or in Daniel and Malehya's property did they carry out any kind of forensic examination for evidence. An eyeball search of a property is neither use nor ornament when you're looking for evidence of potential nefarious circumstance. Unless, of course, you've got someone who has used a type of violence that involves lots of the red stuff and it's not been cleaned up. But there's plenty of other ways to do harm that don't involve the red stuff being part of it. So that's all the things I wanted to cover. Let's see what you guys are saying. The grandmother did say that the mother was welcome to stay. But I don't think that view would have remained the same after she'd actually left and cut everybody off. I hope that we'll get answers sooner rather than later. So Mike says, I still think we will get answers sooner rather than later. And I hope so. I really do. And I think that they have dropped the ball some of the time. But there are also indications in there that they know a damn sight more than they're letting on. And I'll talk about that when I go through the actual things that I've picked out from the documents. But as I say, I haven't finished deciphering it all yet. So, Polar Vortex asks, when revealing information requested by journalists, the police don't reveal evidence, correct? Well, they can reveal evidence, but they can also redact bits of evidence from there if it might harm the investigation. So if it's widely known or it's not going to hamper them in any way to tell us, then they might tell us. But if it's something that's still an unknown in terms of, well, Malehya's saying this and Daniel's saying that and Janie's saying something else, and Daniel said something different to the first 3 times he said it when he spoke again on the 4th time, then if they set that out for all of the others to see that are involved, that could hamper them in investigating it. So they can provide evidence, but they will be very careful about what evidence they do provide. For me, it's far more likely that they will redact something that is likely to be evidence than something that is unfounded. That doesn't mean that anything that's in there is unfounded. Although for many reasons, I think that they've probably ruled out that Haywood person. So all the warrants weren't in the first week. They delayed asking for phone record analysis until the 16th of May. I've not gone through all the others yet, but I've got a list of when they've kind of saw each of the things, and it's quite disturbing, the things that they waited to ask for, but they may have had reasons for that. So the vortex, my dog likes to help because she's about the same size as a cat. So she does get on my desk. She's got a little pillow that she lies on my desk. So sometimes she does get involved, and usually when I'm in the middle of an important conversation with someone, and she'll pop her head onto camera, and it's really embarrassing. She has to be banned from the room when I'm on court hearings that are remote. But I just love all animals. I absolutely do. Animals and children, I adore. I don't. Susanna says, I think that because neither of the three turned on each other, it means whatever happened was an accident. If one person did something, they would have been ratted on. I'm not. I wouldn't say that's necessarily true. From experience, often where something happens, even if it's a deliberate, willful act, they can easily convince a person in the moment that it wasn't. And so they help with a cover up. And then by the time they've realised what did actually happen, it's too late and they're involved. And so they struggle to come clean about what the other person did. Also, families, very close-knit families, and in particular, very close-knit families who have criminal involvement, are very used to sorting things out for each other. So it isn't always the case that it's got to be an accident if they don't turn on each other. In any event, Daniel has attempted to blame Malehya, certainly to the public, if not to the RCMP. And Malehya has made some comments, both to the RCMP and in the messages that we've seen, that kind of hint towards having suspicion about Daniel. Also, often, regardless of what happens or what happened, an innocent parent will accuse the other parent, whether they did something or not. Because the innocent mind goes, well, I didn't do it, but how do I know you didn't do it? So I don't think any version of events is ruled out by the fact of the way that the parents are acting. That's not to say it wasn't an accident, because there's a very good chance that it might have been. And the idea that Jack and Lilly might have gotten into some substances accidentally is a potential, and it would explain why both of them are not here. Although there are other reasons why more than one child would be harmed at once. And certainly retribution against another person. Say, for example, who they find out maybe planning to leave or something, is a potential reason. In terms of the bio dad, they certainly delved into it because they had 3 tips. So they had 1 tip on the 2nd, 1 tip in the early hours of the 3rd, which was Malehya, and then another one on the 6th, or the 7th, 6th, I think. 7th, on the 7th, that he'd been seen in a hotel with the children. But on each occasion, officers went to the house, he was there, not out with the children. So because they went immediately that the tip was received, kind of rules out the possibility that it was him. They were suspicious of Daniel. Not got far enough along to say for definite whether that is still true, but I can tell you now from the wording, having seen how people phrase things in law enforcement when they are suspicious about people, they were definitely suspicious of him. Mums have a range of motives that they can potentially have for harming their own children. But I think she's the less likely of the two, in my opinion. There's lots of reasons that a stepdad might want to get rid of them. Certainly. So one reason that an actual mother might is because the children remind them of their ex, particularly if the ex was abusive. And then Angelina says, RCMP say the situation didn't meet. I've just remembered that you can do that. Apologies, everybody. I've been doing it all the way through when I spoke about each question, if I'd have remembered. Didn't meet the criteria for an Amber Alert. That's accurate. It didn't. Malehya said a few times that she was pushing for one. It is a potential reason why she told them that it might be Cody. I find it hard to believe that she believed it might be Cody, because she's told us in text messages to Belinda and to Sonny that she didn't give Belinda or Cody the address of where they were living. So Cody wouldn't have known where to go and get the children from. So I don't think she believed it. It could have been a diversion tactic, or it could have been a tactic to try and get them to issue an Amber Alert. The Amber Alert scenario is one of the reasons why I believe that they ruled out the Haywood tip when it came in, because it describes a vehicle and it describes a person, an adult. In those circumstances, when that tip was received and looked at, if they thought it was a credible tip, they'd have issued an Amber Alert with those details on. Yeah, I'm pretty certain that they've stopped focusing or looking at Cody, and I think it's fair to say that even at the time that they were looking at him, they were pretty clear that he probably wasn't involved. Indeed, she could have made that other report. We don't know who made that report. We've got a name. It's a name that does have a Facebook account related to it that's from that area. That doesn't mean to say it was that person. We also don't know if that person knows any of the family and so may have been asked to assist. Yeah, I'm not a fan of any parent who doesn't want to have anything to do with their children. Any parent who doesn't want to have anything to do with the children, and there are mothers who are like that as well. But that doesn't mean that he did anything to them, and in fact, it makes it less likely he did anything to them, because why would he put himself at any risk? Risk of ruining his life when they're not in his life. They're having no impact on him. I don't think they've officially cleared anybody, so they've certainly not officially cleared Daniel and Malehya. I've not seen anything so far in the records that uses the phrase officially cleared in relation to Cody either, but just from the wording of it, it leads me to believe that, they're not too focused on him, which doesn't mean to say he didn't do anything, but I think there's lots of reasons why it's unlikely to be him. Yes, it was at 12:45, and by 3 a.m. they arrived at Belinda's property and spoke to Cody, who was there. Yeah, Paula, it could very easily have been a diversion tactic. It could literally have been an opportunity to have a pop at Cody, because by all accounts he wasn't very nice to her. There are lots of reasons. I don't know anything particularly about Justin or his past or anything. And I've not seen anything that makes me super suspicious, apart from the fact that he looked like he didn't have a care in the world when he was sat on that ATV in the picture that was taken by a drone. So that in itself was a little bit concerning from my point of view, as was how clean the ATV was. But I've not seen anything specific that makes me suspicious of him apart from that. I have seen other mothers who completely don't interact And that doesn't always mean that they're guilty of something. But usually, even if they won't go on camera for the news, they will do things like put Facebook posts out, put flyers up. The complete lack of action from what we can see, and obviously we can't see everything that they're doing all of the time, so we may be wrong about it, but it's concerning. And that linked with the words she used around pain and sorrow, which is more a grief terminology, leads me to believe she knows that they're not coming back. Not necessarily that she did whatever it was, but that she knows they're not coming back for whatever reason. Susanna, they did interrogate both Daniel and Malehya early on. Well, they questioned them. I wouldn't call it an interrogation. They describe it as having taken statements. We don't have the recordings of those conversations. We have a summary. The summary is written in a way that makes me question how in depth the questions were. So there are kind of points referenced that make me go, why didn't you ask as the very next question something that delves into that? So, for example, Daniel goes through his banking records to say where he went on Thursday, and he could identify from his banking records on his banking app that he went to Dollarama and Lawton's. I can't remember what it was called then for a minute. On that banking app, it would have the time of the transaction. They don't ask him, or if they do ask him, he doesn't tell them. But given that the whole timeline is an important piece, it bothers me that they didn't say, well, what time does that transaction show us in Dollarama? So, yeah, we don't have the interview under caution, or in the US you'd call it a Mirandized interview. We don't have details of those that I can see from as far as I've got. And it's unlikely they'd give those to us in any event, because if they've really dug into things, so Daniel said he was in there for 4 hours, if they've really dug into things, they're not going to want the others to know what he's come up with in answer to those questions. So whether they are in there, I highly doubt. If I find them, I will tell you. What I haven't come across yet, to your point, Mike, is the grandfather's statement having been taken. And I'm up to, what about the 13th of May in terms of the detail of it. So I don't know when they spoke to him. But yeah, it's a very good question. That could go either way, Polar. It could be it was an accident and that's what was making him cry because he cared about the kids. Could have been crying because he knows it was something nefarious and he doesn't want to lose his brother to a life in prison. So there's always like two ways of looking at things. So it's really hard to say, well, that piece of information points me in a certain direction, because you always look at different things. Yeah, mothers do tend to know the majority of the time. I think you're right. We've got a sixth sense. Like, I can, even now, if I'm fast asleep and my 19-year-old cries, I hear her. Not that she does it very often, but, you know, if she cries for some reason, I hear her. Also, a laugh sounds a lot like she does when she's crying. So when she's on the calls to her friends late at night, she starts laughing. I think she's crying, and I have to get up and go and check. But also, there have been times where something's happened and I've known before they rang me that something's going on. See, I wouldn't expect Justin to be not silent, honestly. He's not one of the caregivers for the children. I wouldn't expect him to be coming on social media and onto news channels and things, inserting himself into it. It's not his kids. Fair chance that Daniel, Malehya and Janie know, certainly. And I think there is a reasonably good chance that Daniel would have asked, or Janie would have asked, Justin and Earl to come and help and Ron with the cover-up. And if Ron was involved, Logan would have been told. Yeah. I think the problem is not everybody responds the same way to being badmouthed. Some people just kind of keep it internalized, what their thoughts are about that. We do only need one weak link, and hopefully there is one in that chain somewhere that will break at some point. I did pick up on that, Carla. So Ron Mackenzie was interviewed by two officers and one of them was called Mackenzie. And it did make me think, surely in a place that small, you're not going to have two Mackenzies that aren't related. So yeah, that certainly bothered me. No, so Malehya did actually tell the RCMP what size their shoes were. She said Lily was in a 12 and Jack was in a 10, I think. Neither of them were a size 11, which is the size of boot print found on the train tracks. Unless you know something I don't, Kimmer, and that there is some evidence that she bought a size 11. I've not seen that at this point. My understanding is that the dogs had a scent in the driveway, but nowhere else. They also traversed about a kilometre around where the boot prints were found, and they didn't have a scent there either. Yeah, Carla, I think the question sounded cursory for a lot of them, including the things that initially they were asking Daniel and Malehya. And it bothers me that they don't appear to have delved in depth with anybody. Same with the teacher. The summary is like 4 lines or something. Teachers know children almost as well as families do, and sometimes better. And I would be digging for as much information as I could from an independent source about the children. So I'd have spent a good time with the teachers. It's not so much in Nova Scotia, Cynthia, it's the fact that in Lansdowne Station there's only about 100 residents. So are there non-related Mackenzies in a group of 100 people? And I don't know what the answer to that question is. But it made me blink and look twice. I don't know whether she will get Meadow back, Mike, and the reason for that is even if she didn't do anything nefarious to Jack and Lily, and they haven't cleared it yet, so she could still be in the picture. But even if she didn't do anything nefarious to them in terms of the disappearance, she kept them in that property, which the conditions were poor in. There were several occurrences that were recorded by picture or other means of the children having black eyes. And she's made allegations since that Daniel was abusive and controlling, and also that he picked on Jack and sometimes Lily. And a parent who remains in that type of relationship is going to be a problematic proposition for returning a child to. So very much depends. So if she is, at the point that she gets the chance to have her back, she's in a different relationship that is assessed and is a healthy one, that, there are other things that demonstrate that those circumstances are not going to repeat themselves, and she might. But it's not a dead certainty, let me describe it like that. Kimmer, I haven't read it all yet, so you could very well be right. So I will kind of come back to it once I've gone through it all. I'm just doing it very methodically, and instead of scanning it and then having to go back through it, I'm going through it like with a fine-tooth comb right from the word get-go. Right, guys, I'm going to leave it there. I was going to do a second live tonight, but I've got a pounding headache. I think it's from yesterday. Spending all day in the hospital with my father-in-law. Just horrible environments, aren't they? And it was quite stressful, and I had to stand up all day, which my back doesn't like. So I think that's where it's come from. But it's a stinking headache, and I'll get distracted, and it's about statistics, which will make it even more easy to distract me, because it's not exactly the topic of the century. But I will potentially do it tomorrow during the day as a video instead, and post it, and then I'll come on tomorrow night and do what I was going to do tomorrow night, which I can't actually remember what the topic is for tomorrow night. But the next one, which, as I say, will probably be a video unless I get a quiet moment in the day when I can do a live, is going to be around the difference between stranger danger and the danger at home. So we teach children all about stranger danger, and there's always an emphasis on it. But statistically, you're more likely to be harmed by somebody who's in your household, and we don't teach children about that. And it should be a big part of primary school education, as far as I'm concerned. So we'll delve a little bit into the statistics, and they're not just generalised statistics that I've got. I've got some generalised ones, but I've also got some Nova Scotia ones. And that helps us to kind of narrow down what we think is more likely and less likely. But I shall leave it there. Thank you all for joining me, and thank you to anybody who watches on the replay. If you can all hit the like on the way out, I would be really, really grateful. And if you're not subscribed, but you're here, please do subscribe. It's such a small channel at the moment, and I really would like it to grow and get in front of more people. So I'd really appreciate that if at all possible. And aside from that, it just remains for me to say, look after yourselves, look after each other, and I will see you tomorrow.